How should I structure my estate plan in Georgia? Hi, I'm estate planning and probate attorney Zach Beck with Peach State Wills and Trust, a division of the Beck Law Firm LLC here in Lawrenceville, Georgia, and we'll answer that question in today's video. So, how should you structure your estate plan in Georgia? Well, a properly structured estate plan should do three main things. It should plan for the disposition of your assets upon your passing. It should plan for someone to have the authority to manage your money, your property, and your personal business affairs should you become incapacitated. And it should plan for someone to have the authority to make healthcare decisions for you in accordance with your known preferences in the event that you are no longer able to manage your own healthcare. In Georgia, there are 3 to 4 main documents that we use to accomplish these goals. First, to distribute your assets in accordance with your wishes upon your passing. This can be done in either one of 2 main ways, a will-based plan or a revocable living trust plan. With a will plan, a will is a document that you execute that only has power upon your death. It has no change to how you own the assets. You execute a will, and in that will, you set up a distribution of your assets to the beneficiaries that you want, and you can name guardians for minor children as well. Wills, once you die, have to go through probate, and any assets that you have that don't have beneficiary designations on them will need to be retitled into the name of the intended beneficiary through that probate process. While probate isn't a difficult or overly burdensome process, it can be time-consuming. In contrast, you could use a revocable living trust-based plan. With a trust-based plan, the trust has power both while you are alive and after you pass. When you execute a revocable living trust-based plan, you transfer ownership of everything that you have, with some minor exceptions, into the trust so that you as an individual no longer own it, you as trustee of the trust too. Properly used, the revocable living trust-based plan avoids probate, as you, the individual, didn't own anything, the trust did. When you pass, your successor trustees, as you've nominated in the trust itself, will manage and distribute your assets in accordance with your wishes. Further, just like with a will-based plan, you have the ability to name guardians for minor children in a trust as well. With a trust-based plan, you will also have what's known as a pour-over will that will catch any assets that weren't put into the trust while you were alive and move them into the trust to be administered after your death. Second, in order to have someone who can manage your money, your property, and your personal business affairs should you become incapacitated, a properly structured estate plan should include a durable power of attorney. This lets you select an agent and successor agents who can step in and deal with the IRS, deal with real estate taxes, deal with Social Security, deal with writing checks for your bills, and making sure that when you're incapacitated, your financial life doesn't stop and doesn't fall apart. And lastly, a properly structured estate plan includes an advance directive for healthcare. This allows you to nominate agents to manage your healthcare for you should you no longer be able to do so, and also allows you to give guidance to those agents for how you'd like to be treated in a couple of common end-of-life scenarios. With all of these documents together, that is how you get a properly structured estate plan in Georgia so that your heirs and your beneficiaries know what your wishes are and know how to have them followed. For more information about estate planning in Georgia, download our free guide to estate planning at peachstatewills.com or give us a call at 678-344-5342.